At 13 years old, she typed 3 words into a search bar that no child should ever have to search. Can I put myself up for adoption? Not because she didn't have a home, not because she didn't have a mother, but because going home every single day felt like walking into a war zone, and she had the scars both inside and out to prove it. This is a story about a real teenager, a real family, and a legal question that more kids than you might think are desperately asking. And by the end of this video, you're going to understand not just what the law actually says, but what options genuinely exist for children trapped in situations like this one. Let's start with who this girl is. She's 13. She lost her biological father when she was young, and a couple of years after that loss, her mother remarried. On paper, it was a blended family: a stepfather, younger half-siblings, and older sister. In reality, it was something far darker. From the very beginning, the stepfather was openly racist, misogynistic, and homophobic. These weren't occasional slip-ups or bad days. This was the baseline. This was the atmosphere this child breathed every single day inside what was supposed to be her home. Now here's why this story matters legally, and why it matters to anyone watching. When a child is being abused, and the systems designed to protect them keep failing, what recourse does that child actually have? Can a minor legally remove themselves from a dangerous household? Can they choose a different family? Can they, in any meaningful sense, put themselves up for adoption? These are not simple questions, and the answers might surprise you. Before we get into the legal breakdown, let me walk you through what this girl actually lived through, because context matters enormously here. When she was around 10 or 11 years old, she accidentally burned one of her younger half-siblings with hot food. It was an accident, the kind of thing that happens in households everywhere. But the stepfather's response was not a consequence. It was a punishment campaign. He struck her 25 times with a belt. He forced her, a 10-year-old child, to shovel dirt with a wheelbarrow for hours every day. He turned her into a household laborer on top of already being responsible for consistent cleaning duties. For a child of that age, this crossed well beyond discipline into abuse, legally and by any reasonable human standard. Her reaction at 10 years old was to run. She ran away from home. When she was found, she lied and said she had been abducted, hoping that the truth that she was fleeing her own house wouldn't come out. It came out within a day, and rather than anyone asking why a 10-year-old preferred the story of being kidnapped over going home, she was sent to a psychiatric facility and came out on antidepressants. Read that again. A child ran away from abuse. The system's response was to medicate her and send her back. Things continued. Her mother filed domestic abuse charges against the stepfather multiple times. There were hospital visits. The stepfather began calling the girls in the home, including this child and her mother, sexually degrading names on a regular basis. This was the environment. This was everyday life. Then came 5th grade. She was caught secretly texting friends on a hidden tablet, and discovered among those messages was something heartbreaking. She had been self-harming, and she had sent a photo of her injuries to a friend who was worried about her. A friend told an adult. CPS got involved for the second time, and here is where the system failed her in one of the most stunning ways imaginable. CPS investigated, looked at everything, and attributed her behavior to, quote, middle child syndrome. Those were their words. They dismissed the abuse allegations and closed the case. She was then punished for days by both her mother and stepfather for what had been discovered. She ran away again, was caught again, and was sent back to a psychiatric facility, this time with documented homicidal and suicidal ideation. The system had now twice looked at this child's life and essentially handed her back. After that, any restraint the stepfather had previously shown disappeared entirely. He began hitting her in the face, despite the fact that she had braces, which caused scarring on the inside of her mouth. He delivered what she described as one of the worst beatings she ever received, during which he made vile threats about her future, punched and slapped her repeatedly, dragged her by her hair, pinned her to the floor using his body weight, he is well over 300 pounds, and slammed her into a wall. She is 13 years old. Since then, she has learned to survive by becoming invisible. Better behavior, she calls it. meaning she has learned to keep her head down, stay quiet, and not give him reasons to escalate. This is not healing. This is a child who has been conditioned to manage her abuser, and so she asks the question, can I put myself up for adoption? Let's talk about what the law actually says. In the United States, minors cannot legally place themselves up for adoption. Adoption is a legal process that terminates parental rights, and that process requires either the voluntary relinquishment of rights by the parents or a court order terminating those rights involuntarily. A child cannot initiate that process unilaterally. The law does not currently give minors that direct power. However, and this is critically important, that does not mean a child in this situation is legally powerless, not even close. The first and most important legal concept here is called emancipation. In most states, a minor can petition a court to be legally recognized as an adult before turning 18. To be granted emancipation, the minor generally needs to demonstrate that they can support themselves financially, that emancipation is in their best interest, and sometimes that they have a plan for housing and stability. It's not easy, and courts don't grant it automatically, but it is a real legal pathway that has been used by minors in abusive situations. The second pathway is guardianship. If there is a trusted adult in this girl's life, a grandparent, aunt, uncle, family friend, that person can petition the court to become her legal guardian. This does not terminate her parents' rights permanently the way adoption does, but it legally moves her out of the home and places her under the protection and care of someone she trusts. This is often faster and more accessible than full adoption or emancipation proceedings. Third, and perhaps most urgently relevant here, she can request her own legal representation. In many states, children involved in custody or abuse proceedings have the right to a guardian ad litem, an attorney appointed specifically to represent the child's interests, not the parents' interests, not the state's interests, but hers. Given that CPS has already failed her twice, having an independent legal voice advocating specifically for her could change everything. Fourth, if she is ever again in a situation where she can speak to a mandated reporter, a teacher, a school counselor, a doctor, she should know that she has the right to tell that person exactly what is happening and ask them to report it. She also has the right to call the Child Help National Child Abuse Hotline herself. The number is 1-800-422-4453. That line is available 24 hours a day, 7 days a week, and she can call anonymously. Fifth, and this is something many people don't realize, in some states, children above a certain age, typically 12 to 14, are given significant weight in custody and placement decisions by family courts. Her voice legally matters more than she may know. A judge hearing directly from her about what has happened, on the record, with documentation, could lead to outcomes that CPS field workers have repeatedly failed to reach. Now here's the deeper lesson, and it applies whether you are a teenager in a situation like this, a parent watching this, or simply someone who cares about children. The systems designed to protect children, CPS, psychiatric facilities, even well-meaning mandated reporters, are imperfect, sometimes catastrophically so. Middle child syndrome is not a diagnosis, it is a dismissal. And when a child is dismissed by the system, it doesn't mean the abuse isn't real. It means the system failed to do its job. If you know a child who is in a situation like this, who seems to be managing, who seems to be keeping their head down, who has maybe had run-ins with authorities or mental health facilities, don't assume quiet means safe. Sometimes quiet means survival mode. And if you are a young person watching this and you recognize yourself in this story, I need you to hear this clearly. You have not done anything wrong. Running away, lying to protect yourself, self-harm as a response to unbearable pain, these are not character flaws. These are the responses of a person under pressure that no child should be under. You deserve safety. You deserve stability. And the law, imperfect as it is, does have pathways that can get you there. Document everything you can. Tell a trusted adult, a teacher, a coach, a relative, anyone. Call the hotline. Ask for a lawyer who represents you and only you. And know that the question you searched, "Can I put myself up for adoption?" is not a sign that something is wrong with you. It is a sign that you are trying to survive, and that instinct to find safety is exactly right. If any of this applies to your situation or someone you care about, please share this video. It could reach someone who needs to hear it. And if you want to keep learning about how the law intersects with the real situations people face every day, the messy, complicated, and deeply human moments where legal knowledge can actually change lives, subscribe to this channel. We cover these stories because they matter, and because the more people understand their rights, the harder it becomes for those rights to be ignored.